Welcome to the WN Legal Podcast.
Welcome to WN Legal's podcast. My name is Khew, and together with me I have Aimee Price. And what we'll be talking about today is Violence Restraining Order. In fact, we'll be talking about the new Violence Restraining Order Act. After the amendment as of 1st of July 2017, you would have seen in our blog that I have posted something about violence restraining orders or restraining orders in general. But that is about the old act. As of 1st of July, a few months ago, there have been new laws in place. And then there is such thing now as a conduct agreement. Aimee will be talking about that. Now, before we go on further, I do want to provide a brief disclaimer that this podcast is a general discussion about the areas of law that we practice in, that the public may be interested in. It should not be taken as a substitute for legal advice whatsoever, as each case is different. So I do recommend that you speak to us before you decide to use any of what we've said as advice. In any event, that shouldn't be the case. Okay,
so my name's Aimee and Khew has introduced me, and I'm another fellow solicitor at the firm. Now, firstly, Khew, I suppose, if you could give us a bit of a rundown as to the previous violence restraining orders, and then what has changed, I suppose, in respect to the new family violence restraining orders. So if you could just give a brief comparison about the two and how, I suppose, clients can negotiate their way around the two and how they work.
Yes, the older Restraining Orders Act, that is prior to 1st of July 2017, they separated restraining orders into violence restraining order and also misconduct restraining order. So one is under Section 11A, that's the violence restraining order, and that's Section 34, and that's misconduct restraining orders. So they have two different breeds of restraining orders. In the past, violence restraining orders encompassed two kinds. It encompassed domestic violence and it encompassed personal violence. Now, that is the violence restraining order. If indeed made final, it stays final for 2 years. And that feature is the same now with the new violence restraining order. But the previous violence restraining order, the old act, the Restraining Orders Act talks about Section 11A specifically, about how Section 11A, the Violence Restraining Orders Act, deals with domestic violence and personal violence. The new act does not do that anymore. The new act splits domestic violence into a separate section. It's now in Section 10D. To simply put it, as of 1st of July 2017, there are three different legislation in respect to restraining order. There is family violence restraining order under the new Section 10D. There's violence restraining order under Section 11A, and there's misconduct restraining order under Section 34. So the new act splits Section 11A into two different pieces, so to say. Mm-hmm. The family violence restraining order under 10D now talks about acts of family violence. They have then now defined family violence. Mm-hmm. So in the past, when our clients come in, we only address what violence restraining order is. But now the criteria for violence restraining order and family violence restraining order is completely different. Mm-hmm. So if you have a neighbor dispute, that does not fall under the new act of Section 10E. That falls under the new act of Section 11A, violence restraining order. And the definition of to get a violence restraining order has changed significantly. So has it for the family violence restraining order for 10D. It's a bit confusing. So you can speak to us and we'll obviously give you advice on your case-by-case basis. Section 34, however, misconduct restraining order hasn't changed much. I believe there's a little bit, but it's not much. It hasn't changed as much as compared to
And I suppose, Khew, in respect to the violence restraining orders and the family violence restraining orders, what is satisfied? I mean, what do you need to satisfy in order to get a family violence restraining order? What relationship do you need to be in? How do we deal with that? I mean, from my understanding, I would obviously safely say that it's married couples, de facto couples, anyone in a relationship, really. Yeah. But how do we define sort of the length of that relationship? Is this where does that is there a line in relation to the threshold, or
There is. So to comply with Family Violence Restraining Orders Act, so that means if you apply for Family Violence Restraining Order under the new act, family relationship is defined in Section 4 the Restraining Orders Act. People who are or were married to each other, who are or were in a de facto relationship with each other, who are or were related to each other, one whom a child is who ordinarily resides or resided with the other person, and one that regularly stays or resides or stayed with the other person, or one whom was or is a child whom the other person is a guardian, or one who have or had an intimate personal relationship or other personal relationship with each other. Other personal relationship includes domestic relationship of domestic nature, in which the lives of the persons are interrelated and the actions of one person affects the other. So it's a very vague term, but when you apply for a restraining order or family violence one, you will get a checklist from the court, actually, and you will tick through it. And
to ensure that you satisfy
yes.
that section before you apply, so
yes.
as to not apply for the wrong
That's
wrong
correct.
order. Yeah,
so
okay.
How do you know whether family violence restraining order applies to you? Look at Section 4 of the Restraining Orders Act. You've asked me the question of how do you satisfy the application for a family violence restraining order. Under Section 10D of the Restraining Orders Act, as the new one, says that the court must grant a family violence restraining order if it is satisfied. Not must. The court may make a family violence restraining order if it is satisfied that the respondent has committed an act of family violence against the other person, the applicant, and is again likely to do so again. Family violence is defined under the new act again, new section. Family violence, it includes the term of reference, the very big term of violence or threat of violence, and any other behavior by the person that coerces or controls a family member or causes the member to be fearful. Now, family violence or threat of violence violence or threat of violence constitutes family violence. And that includes assault, sexual assault, stalking, cyber stalking, repeated derogatory remarks against family members, damaging or destroying property, death, causing death or injury to an animal, and the list goes on.
Yeah, I think what's important from this new term in respect to the family violence, as it encompasses a lot more of, I suppose, the intrinsic issues in relation to marriages and de facto relationships, things that happen. So as opposed to the violence restraining orders where you would have to satisfy that the other person's conduct was offensive or intimidatory in nature, this just opens the door to a whole another behaviour.
The old act, the old Restraining Orders Act usually says that, I believe, from memory, it says that to satisfy an act of violence, the person's behavior that is intimidatory or offensive, that very word intimidatory and offensive is so broad. But that was the old law, and now they've taken that out and they've replaced it with violence or threat of violence. And that is a lot more specific.
Yeah, and I think it's important, especially with the way that a lot of intimidating and derogatory behaviour occurs nowadays. A lot of it is online based and social, and cyber based. And this new family violence restraining order actually makes specific mention that a cyber based bullying or threats of
Absolutely
bullying,
correct.
threats of uploading media or whatever the case may be, actually
Absolutely
falls
correct.
within that term of family violence, which is really important. So instead
Absolutely correct.
of, prior to the 1st of July, having to satisfy that behaviour was intimidatory or offensive, it now automatically falls part of that family violence because of the prevalence of that sort of behaviour.
That's
So
correct.
that's a good protection, I suppose, for anyone wanting to apply for a family violence order after the 1st of July, because it does make it a little bit easier in terms of satisfying these elements when they're specifically listed, I suppose, as opposed to it being very broad brush.
Yep. So I think to simply put it, it has been fine-tuned by the
most
parliamentarians.
definitely.
Now, violence restraining order no longer encompasses family violence. Now, violence restraining order under Section 11A deals with personal violence now. There is actually a new definition for it as well. I'm just going to go through quite quickly and briefly. Most of our clients come in, usually they're dealing with family violence, but there are neighborly disputes.
Yeah.
Neighborly disputes falls under either Section 34, misconduct, restraining order. Now, that definition hasn't changed as far as I could remember. I mean, actually, we've seen it. Don't quote me on this. But I think under Section 34, it still goes on and talks about, just bear with me for a moment, behavior that can be expected to be intimidating and offensive. Yes, so it has stayed the same under Section 34. So if you're a neighbor, for example, or you're going against just a random stranger that has been continuously harassing you, continuously is the term, okay? And if they continue to do so, you can choose to either do it under Section 11A, violence restraining order, or 34, misconduct restraining order. 34 is easier based on the wording because it is indeed intimidating and offensive. The drawback of misconduct restraining order, from my experience in the many cases we've dealt with, is the police don't quite enforce them, unfortunately, especially in circumstances where there are neighbor disputes. They tend to respond better to violence restraining order because violence restraining order has the term violence. Section 11A denotes the very definition itself of what violence is. And there's a new definition as well. Right, moving aside from, I guess, the new act and how it's a bit different.
Yeah. I suppose the other thing that's different with the new act, which is what I will talk about as well. So Khew's obviously addressed how we satisfy the family violence order. Now, Section 10H of the Restraining Orders Act also now includes a section on conduct agreements. Now, as opposed to an old violence restraining order, I suppose old being pre-1st of July this year, we could, I suppose, elect to do an undertaking in relation to finalising a violence restraining order. However, the issue with an undertaking
is that it's not binding.
It's not binding. So it's basically a promise that I won't do this to you, Khew, and you won't do that to me, or something along those lines.
Is that a threat?
Well, maybe. But I suppose if that person was to break that promise and to continue contacting you or to continue behaving in the same way, there's actually, it's not enforceable. The police will actually not do anything. There's no legal repercussions for an undertaking. So that was always the risk with the undertaking.
There are legal repercussions if you breach an undertaking. It's another reason to reapply again, but
it's not automatically.
Yeah, it's neither here nor there. You're in the middle of the desert still.
Yeah, and you're still sort of in the same boat that you would have been when you first initially applied. Now, in relation to the family violence restraining order, what we have now is what's called a conduct agreement. Now, a conduct agreement is enforceable by the police. So basically, if someone agrees to a conduct agreement and they breach that, the police can enforce this. Now, the conduct agreement is basically a without admission, and I'll get Khew is probably a little bit more savvy with his terminology here, but it's a without admission as to need acceptance of the VRO, effectively. So the person who is being bound by the violence restraining order can agree to a conduct agreement without having to admit to the allegations that are being brought forward, and without having them be tested before the court as well. So
on the dispute of facts.
On the dispute of facts. So that's obviously a quicker way of resolving a matter without it obviously having to go to a final trial hearing. This is somewhat, it won't work in every situation, obviously, but where it can, it is useful. And the good thing about it, as opposed to the undertaking, is that it is enforceable, which is what we
essentially,
protects the client. So
essentially,
it's what we.
You've been to court this morning on
well,
this
that's
very
right.
same thing. So
just this morning I was at the Midland Magistrates Court and was negotiating a conduct agreement between two parties, and the magistrate actually said, "Oh, you might have to give me a little bit of assistance here because I've actually never done one before." So it's that new.
It's pretty new.
Very new. Yeah. So even one of the magistrates was not entirely sure how to affect the conduct agreement, but as time goes on,
we've been through the process. So it's pretty much if you agree to a conduct agreement, if the respondent agrees to a conduct agreement, the court will enforce the agreement like an order. So to simply put it, when negotiating, we can put on the table obviously an undertaking, but we know how well it goes. It does resolve a lot of disputes most of the time if the parties are amicable, but if it's serious, conduct agreement is something that everyone should consider. That's in the circumstances of a family violence restraining order.
Yeah, it doesn't apply to normal violence restraining orders.
Not that I'm aware, at least, because of the way the law is constructed.
Yeah.
So in violence restraining order, there are separate mechanisms, but of similar means. I think it's under Section 33. And it does say that what happens is if the respondent does not object to any interim orders being in place to be made final, it's also done on a without admission as to liability basis. Yeah. What it means is, look, I'm not saying I'm wrong. I'm not saying I've done anything wrong. I'm just going to agree to it because I don't want to fight it. The
because
court
it's
does
easier
understand
and it's quicker. And
the court actually does recognize that, and it's not at all prejudicial. What is prejudicial is if undertaking's not resolved, the situation, if conduct agreement's not agreed upon, and if the interim order is not consented upon, and you go to trial and you lose, there is a finding of fact. And that is a serious issue because the court will record by way of reasoning why they believe the applicant should win and what evidence they've considered to do in doing so. Very recently, we've done quite a lot of restraining order trials, and obviously when they go to trial and there's a finding of fact, and I've always most of the time in the circumstances that I've represented my client, the finding of fact usually is very damning to the other party. Long story short, if the parties do settle, it's probably the best thing, and every lawyer should, in my opinion at least. I can't speak on behalf of the rest of my peers or colleagues. But if the opportunity presents itself and everyone agrees, then a conduct agreement is something very
definitely to be considered. Yeah, because I suppose instead of with court backlog at the moment, realistically, if this morning's hearing that I attended on behalf of Khew was to not go by way of conduct agreement and was to proceed to a final trial hearing, we're looking at probably April, May, June. So that's what are we in? It's about 7 months away. Yep. So
same as in Joondalup.
Each court is different, but it's generally you're looking at least a 6 month wait. So in the interest of resolving the matter quickly and letting everyone move on with their lives, it is a good option. But obviously it won't work in every situation. But where it is a possibility, it seems like a good avenue, definitely.
Yeah, but look, that doesn't mean our practice actively campaigns in settling everything. In some circumstances, and actually most circumstances in our cases that we've dealt with, the only resolution is by way of a trial. And that had happened on a few occasions and in my recent clients as well. So I'm not saying that, it is the best method to resolve is obviously the best option, but sometimes you just can't.
You just can't. Yeah.
Look, costs about this is a separate issue. So if the applicant wins in the trial or the respondent wins, the issue of cost is a completely separate issue. We'll be talking about that sometime.
Yeah, that might be
in
another
the distant future.
Another podcast.
Yes. Alrighty. Anything else?
No,
to say?
Nothing further from me. So I hope that's been informative and
Yes.
given a little bit of insight, whilst it might be a little bit confusing.
No problem.
It hopefully has given a little bit of insight as to the old law, the new law, and how it all
Goes.
binds in together.
All right. Thank you. Thanks, Aimee.
Thanks very much.
Thank
Bye.
you. Bye.